Hello everyone. Welcome to our final employment webinar for 2020 called Forward Planning: What UK Employers Expect in 2021. My name is Ranjit Dinza. I'm head of the Employment, Pensions, Immigration and Compliance teams in the UK called EPIC. I'm joined today by my colleague Nick Thorpe, who is a partner and head of our employment team in London. 2020 has been an unprecedented year for all of us. There have been massive changes in the way we work caused by the pandemic. There was the introduction of a previously unknown concept called furlough, which we are now all familiar with. And virtual hearings in the Employment Tribunal have become the new normal. All of this nearly overshadowed key anniversaries. 50 years of the Equal Pay Act, 25 years since disability discrimination law was introduced in the UK, and 10 years since the consolidation of discrimination law in the Equality Act 2010. It appears the pace of change will not slow down, given the recession we are heading into, and the challenges of navigating new ways of working. There is so much Nick and I could review. However, we only have 30 minutes, so we've decided to focus on a few key areas. We think the big themes for 2021 are going to be status, pay gap reporting, the impact of Brexit, and litigation trends. So Nick will review recent case law on status, and I will remind you of compliance with IR35 that needs to take place before April 2021. Nick's going to remind us of developments over the past 3 years with gender pay gap reporting, and I will look at calls for ethnicity pay gap reporting. We can't ignore Brexit, so Nick's going to have a look at the possible divergence with EU law and any impact of Brexit on domestic legislation. Finally, I will look at some litigation trends. Nick, what's been happening in case law?
Thank you, Ranjit. So, our first prediction for 2021, and it's perhaps not a particularly bold prediction, is that we'll see an increase in status litigation next year. Hardly a month went by in 2019 without a status claim hitting the headlines. The battleground was over worker status rather than employment status, and we saw taxi drivers, couriers and plumbers all successfully argue that they were in fact workers and entitled to worker rights, including minimum wage, holiday pay, and pension contributions. The only case that seemed to buck the trend was Deliveroo, where the Independent Workers Union was unable to convince the Central Arbitration Committee that Deliveroo riders were workers for the purpose of trade union recognition. But the case law was not limited to the so-called gig economy or shared economy. We saw the first public sector status claim brought against the National Gallery. We also saw a former Olympic cyclist bring a status claim against her sporting federation, British Cycling. Both of those claims were defended by members of this team. So why haven't status claims hit the headlines in the same way in 2020? And why are we predicting an increase in status litigation in 2021? Well, the on-demand or online economy has not gone anywhere. In fact, the pandemic has only accelerated the use of new technologies and reinforced the importance of the gig economy. Outside of the gig economy, contingent workers may have been some of the early casualties of the pandemic, as organisations responded to the economic impact by reducing contractor budgets. But there has since been a shift, and we've seen organisations across all sectors continue to expand their use of contingent workers to maintain flexibility in workforce management. No organisation is immune from potential status claims. Many status claims have also been stayed or delayed in the Employment Tribunal pending the outcome of the Uber case in the Supreme Court. For Uber, these status claims represent an existential threat to their business model, and they have fought hard, not just in this jurisdiction, but in others, to overturn worker status decisions. The case was argued in the Supreme Court over summer, and we're awaiting the Supreme Court's judgment imminently. But that doesn't mean that we haven't seen any developments in this area in 2020. In April, we saw workers enjoy increased protections with day one right to a written statement of terms. We also saw the abolition of the Swedish derogation for agency workers, entitling all agency workers now to pay parity after 12 weeks in post. The reference period for determining average week's pay for holiday pay purposes was also increased from 12 weeks to 52 weeks to smooth out significant fluctuations in pay for contingency workers. We also saw a decision in the Employment Tribunal which extended automatic transfer rights and protections under TUPE to workers and not just employees. Now, that decision is not binding on other employment tribunals, but will we see other employment tribunals adopt a similar approach? It's perhaps sensible to wait for confirmation from the appellant courts before changing your practice on transfers of undertaking, but you may want to future-proof your contracts and staff transfer schedules in light of this case. While the Independent Workers Union may have been unsuccessful in Deliveroo, they had more success recently in challenging the government with judicial review over unsafe working conditions for gig economy workers. The court held that the UK government had failed to implement EU health and safety directives properly in not extending certain protections to workers. But should workers also be included when calculating the threshold for collective redundancy purposes? This was a point which was unsuccessfully advanced in the National Gallery case, but we will see unions seek to challenge this with the increased number of redundancy exercises likely in 2021. And what about future rights and developments? What about the recommendations made by Matthew Taylor in his report Good Work? And what about the EU Directive on Transparent and Predictable Working Conditions? These are all points that I'll return to shortly, but for now, let me hand back to Ranjit.
Thank you, Nick. One of the big compliance projects for 2021 will relate to IR35. Now, as you know, employment law recognises 3 types of status: employee, worker, self-employed. But tax law is binary. It only recognises employee or self-employed status. The IR35 changes were due to come into force in April this year, but have been postponed to the 6th of April 2021. You only have 4 months left to comply, and I just want to give you a quick recap. So what is IR35? It's HMRC's attempt to tackle disguised employment. It applies if an individual works for an end user, possibly your company, through an intermediary where the motive is to pay less tax, pay corporation tax rather than PAYE or national insurance. At the moment, the individual contractors assess their own status and account to HMRC. The big change is that the end user, possibly your company, must now determine status from April 2021. So how does an end user determine status? Well, by applying employment law tests. However, HMRC place emphasis on different parts of the test compared to the tax tribunal or the employment tribunal. I'm not going to go through each of these tests now, but I do want to highlight one point: personal service. HMRC rely heavily on this to determine status. Does the company have the right to substitute the person who is going to provide the service? If they do, that's a strong indication of self-employed status. And don't forget, there are lots of other relevant factors besides mutuality of obligation and control that determine status: the use of equipment, integration into an organisation. What HMRC are looking for is whether or not there is a genuine business-to-business commercial arrangement in place or not. So, as I've said, compliance needs to take place from 6th of April 2021 onwards, and you, the end users, have to determine the status. and it will affect any company that uses contractors providing services through an intermediary, unless you're a small employer. And a small employer is defined as someone who has turnover of less than 10.2 million, or a balance sheet of less than 5.1 million, or 50 or less employees. 2 out of those 3 conditions need to be met. So what does this mean for business? Well, you will have to determine the status of your contractors if you're an end user using reasonable care. And I've put reasonable care in bold deliberately. How do you determine status using reasonable care? Some people use a HMRC test. Many of our clients have instead chosen to create tailored questionnaires to determine status. You then have to inform the contractor of your decision through a status determination statement. And you must allow the contractor to disagree with your determination. And most importantly, you must demonstrate compliance. Particularly if HMRC audit you, you need to keep detailed records of your questionnaires, your decisions, the determinations and the disputes. There are lots of practical things to deal with. Are you an end user? Is the contractor providing services through an intermediary? How are communications going to work, particularly if the contractors are at customer sites? But there are much bigger strategic questions, particularly in a world heading towards recession and possible restructures. So what is your company's business model? What services do you require people to provide? And how are those people going to provide those services? As employees, self-employed, outsource, even automate those services and no longer have people? And what will be the risks of your decisions? There is a risk from HMRC to audit, to fine if they disagree. There is a risk from the individual contractors if you determine them to be employees. They may try and enforce their rights in the tribunal. There is a lot to think about before April 2021. Nick, let's talk about our second theme, pay gap reporting.
Thank you. So as Ranjit says, our next big theme for 2021 is pay gap reporting. It has been mandatory for large employers to publish their gender pay gap figures since April 2018. While the regulations initially presented some administrative challenges for employers in collating the relevant data, they've generally been seen as a positive development. As you'll know, employers are required to publish their overall gender pay gap figures, calculated using mean and median average hourly pay. They must also publish the proportion of men and women in each of their 4 pay quartiles, as well as bonus data. ONS, the Office of National Statistics, reported an overall gender pay gap of 17.8% in the first year of publication, and in the second year, a slight decrease at 17.3%. However, 45% of reporting employees had seen an increase in their gender pay gap in the second year. In my experience, where an employer was faced with reporting an increase, it prompted, at the very least, a discussion as to how they might address that. Transparency and market pressures were then seemingly creating greater awareness and driving change. But have we now taken a step backwards? I've seen some rather alarmist commentary which suggests that the impact of COVID-19 on working women and the decision of so few employers to publish their data in 2020 could push back by a generation gender equality. Disappointingly, when enforcement of the mandatory rules was suspended in April this year, less than 50% of employers published their figures voluntarily. Personnel Today also reported that the median pay gap had increased from 11.9% to 12.8%. Although for those of you listening carefully, you'll note that these figures do not tally with the reported figures from other sources for previous years. If anything, we will see the figures published by employers in 2021 receive even greater scrutiny. Employers who did not publish their figures in 2020 will also need to consider whether they'll include those figures in their narrative for 2021. And what if you're faced with another increase? Should you possibly be considering positive action, an area which Hannah and David covered in an earlier webinar? The regulations also included a 5-year commitment on the Secretary of State to review them and publish a report on whether they met the government's overall policy objectives. If we see no change or an increase in the gender pay gap, will we see a further strengthening of the obligations? That review is not due until 2022-23, but before that, will we see reporting obligations in other areas? Perhaps with the introduction of ethnicity pay gap reporting, which Ranjit will now cover.
Thank you, Nick. The question for me is, will ethnicity pay gap reporting become a reality in the UK? If so, will it follow the same principles of gender pay? Is that possible? There seems to be pressure building for ethnicity pay gap reporting in the UK. In 2017, the government commissioned the McGregor-Smith Review, and one of its key recommendations was that ethnicity pay gap reporting should be mandatory. And Theresa May, on the back of that review, issued a consultation document that ended in January 19 called Ethnicity Pay Reporting. And we thought that the regulations would soon follow, but they did not. On the 28th of January 2020, this year, there was the first reading of an equal pay bill that recommended ethnicity reporting. And in July this year, Boris Johnson set up the Commission on Race and Ethnic Disparities, probably as a result of the Black Lives Movement and the apparent disparities of the pandemic on people's health, depending upon their ethnic background. There is a report expected by the end of December. What I want to do is have a look at the Equal Pay Bill a little bit more closely. Now, I don't want to alarm you. It's in its very early stages. The second reading is not scheduled. We don't even know that it will become law. But this is what it's recommending: that Section 78 of the Equality Act, which relates to gender pay, should be amended so it applies to both gender pay and ethnicity pay gap reporting. And not only that, the threshold for which employers need to comply should be reduced from 250 employees to those employers with 100 employees or more. And those employers should set out action plans on how to tackle the difference in pay for both gender and ethnicity pay gaps that are identified. Now again, pressure is building, but we have no date for any legislation. I would suggest that there are challenges in trying to replicate gender pay. One of the biggest challenges is ethnicity classifications. How do you collect data from hundreds of different ethnic groups in a meaningful way is very different to gender, male or female. And which classification should we use? The 2011 Census Categories are often referred to. They have 5 broad categories: white, mixed, Asian, Black, and any other ethnic group. Are they relevant? Are they appropriate? There are data protection issues too. Ethnicity data is sensitive data, and in some organisations it may be possible to identify those individuals given the numbers employed. And then should it be a voluntary process? And if so, will people actually engage? Many individuals do not like being given a label or forced into a category. They want their identity to be fluid. Concepts such as Black or Asian or BAME are broad and easy to hide behind. The experience of a Nigerian will be different to a Jamaican, an Indian to a Bangladeshi in the UK. So what does the future hold? Can gender pay regulations be replicated? Probably not. if it's going to be meaningful? And how are we going to deal with the complexities of identity and data collection? And anyway, is there appetite in the government, given the pandemic and Brexit, to really pursue ethnicity pay gap reporting? I'm not sure, but I could be wrong. Nick, what could be the impact of Brexit?
Thank you, Ranjit. So my last topic today is Brexit. I know you may be on mute, but I can hear your collective groan. But as Ranjit said at the beginning, we cannot do a horizon gazing update without mentioning Brexit. While the decision to leave the EU may have been presented as a simple one in the 2016 referendum, no one could have been left in any doubt in the intervening years that this is far from simple to extract ourselves from a legal framework of which we've been a part for over 40 years. Employment law in the UK has been shaped by EU directives and case law from the Court of Justice for the European Union over the past 40 years, and will continue to be so, I suspect, in future years in some way or another. My last prediction, therefore, is that we'll see a lot more case law arguing about what the guiding principle should be in employment cases. The position is complex, as this slide shows. After the transition period, the supremacy of EU law will continue to apply in certain circumstances. However, appellate courts may depart from previous EU law, and tribunals will no longer be bound by future decisions made by the Court of Justice. So, will we see a divergence from EU laws? That is the million-dollar question. In the government policy paper published under Theresa May's premiership, UK worker rights were to remain aligned with EU employment protections. But any safeguards on worker rights were dropped by Boris Johnson following the general election. But I don't think we're likely to see significant changes, at least in the short term. But what changes could we see? Likely targets for change are the 48-hour working limit and the agency worker regs, both of which are unpopular. Commentators also speculate about the possibility of imposing a cap on the discrimination awards, but there are no concrete plans at this stage to make any changes. But what if your operations and your responsibilities extend beyond the UK to Europe? What happens if you have a European Works Council in place, for example? The European Commission has been clear that at the end of the transition period, EU rules in relation to European Works Councils will no longer apply to the UK. This may have a number of consequences. If English law was the governing law of your European Works Council, then it may result in a change in the governing law. It may also see some European Works Councils become national Works Councils instead. And what about future EU directives, such as the EU Whistleblowing Directive, which must be implemented by Member States by December 2021, and the EU Directive on Transparent and Predictable Working Conditions, which must be implemented by August 2022. Some of these directives have already been, or elements of these directives have already been implemented into UK law, but not all. The EU Whistleblowing Directive, for example, provides measures for protecting the confidentiality of whistleblowers. It also includes concrete timeframes for responding to whistleblowing complaints. Employers will have 7 days to acknowledge a complaint and must provide feedback within a reasonable timeframe with a 3-month long stop date. The directive also reverses the burden of proof in detriment claims. The EU Directive on Transparent and Predictable Working Conditions, on the other hand, includes the right for gig economy workers to request more predictable and secure working conditions after 6 months. So, should you introduce those remaining elements as part of any European or company-wide policy? These are the issues and types of questions that you'll need to consider in the coming years. Some commentators also fear that we'll see a regression of employment protection rights in the UK. I'm not so sure about that. But what has happened to the employment bill? The bill was supposed to cover the right to request a predictable contract, extend redundancy protection for maternity returners, introduce a statutory right for leave for neonatal care, and make flexible working the default. What has also happened to grandparents' leave, to the statutory right to unpaid carers' leave, and to legislation curbing the use of NDAs? It is unclear whether the government intends to take any of these forward. So have they been kicked into the long grass? Or will we see even more radical change promised in 2021 as a result of the pandemic? Only this week, we saw reports that the government intends to launch yet another consultation on limiting the use of non-competes over concerns that they may stifle competition and an entrepreneurial culture in a post-Brexit world. But is this just a distraction from bigger issues or a genuine attempt to effect change? This is a government that likes to challenge the status quo, and it will want to move at pace with its reform agenda. We should therefore expect to see changes in 2021.
Thank you, Nick. So the final topic is litigation trends. Employment tribunal litigation is increasing. The OBR stated last week that the economy had shrunk by 11% since the pandemic started. We also have the largest number of redundancies recorded so far this year, according to the ONS. And unemployment is rising rapidly. It could reach 7.5 or 8% of the working population next year. Against that backdrop, the Employment Tribunal remains a free forum. Anyone can litigate. Claimants don't need a lawyer. And interestingly, virtual hearings have actually encouraged claimants and made them more confident. They can deal with litigation from their living rooms. There's nothing to lose by litigating. So what has the Employment Tribunal done? Well, they've introduced new rules in October 2020 to deal with both the backlog of cases, but also the expected wave, particularly when furlough ends on the 31st of March. Now, I've summarised here the changes, and I just want to pick out three. The first one, multiple claimants can use the same form when they're litigating. Are we going to see the rise of group litigation? And the second bullet point, on Tuesday of this week, early conciliation was extended to a default 6 weeks. Clearly, the aim is to try and get the parties to resolve their disputes early. And look at the very last bullet point. Cases dismissed on withdrawal will no longer be entered on the public register, and this has got to be good news for employers. So what are the top tips? You've got to understand the new Employment Tribunal litigation landscape. We've got to adapt to virtual hearings when preparing for trial. It's a very different experience. Witnesses need to be adept at handling the technology and have several screens and deal with electronic bundles, and also be able to instruct their lawyers separately. You've got to make your dismissals bomb-proof. Which process are you following? Is the investigation thorough? And most importantly, do the outcome letters set out not only the decision, but the reasons for taking that decision? And you have to be ready to deal with an increase in subject access requests. And finally, although the Employment Tribunal is embracing technology, it doesn't mean there aren't teething problems, both with the technology and the variety of employment judges ready to embrace it. So what does the future hold? Litigation is going to be delayed, and a lot of our clients have taken the decision to push the litigation into the next financial year and run with the delays deliberately. Others instead are finding that the delays are allowing them to make better commercial deals with the claimants. Certainly, you have to develop a subject access response strategy. Have you got an internal team that can deal with it? Do you need support? Where will you get that from? But most importantly, does the SAR bundle of evidence, which you will disclose early, contradict or undermine the litigation bundle, which will be prepared much later? And what will your tactics do to your industrial relations? For example, if you adopt a strategy of being litigious and fighting every case, is that going to create greater confrontation in the workplace? So we hope we've given you a few themes to think about as we enter 2021. There was a lot to cover, and we know we haven't left room for questions. Instead, we would invite you to email your Field Fisher contact or any one of the team, and also to look back at the previous webinars on our Field Fisher website and YouTube channel. We want to thank you for joining us today. Goodbye.